Good afternoon, everyone. My name is Alberto Rodriguez, and I'm with the State Bar of Arizona, and this is our fifth installment of Arizona Attorneys Respond. And it's our social media initiative to help you, the public, while we're dealing with the COVID-19 pandemic. So our goal is to ask you guys what your legal issues are. We will try to address them via social media, Facebook, Instagram, even YouTube, LinkedIn. Whichever social media platform you have, we're here to help you. So today, we will focus on family law issues. There's been some news reports that domestic violence has increased. So we thought it was definitely an important topic to cover. And you see that we have with us today, attorney Rachel Frazier Johnson with Rachel Frazier Johnson Law. Want to give you a welcome, Rachel. And I want to thank you for being here and for the willingness that you have to help these folks during these very unforeseen circumstances. So thank you for that.
My pleasure entirely. Thank you for the invitation.
Absolutely. So we'll go ahead and dive in, Rachel. So let me look at some of the questions that we've gotten from folks, and I'll ask you some general questions, and then we'll dive into some of the specifics. So let's start off with, as I mentioned right now, has there been an increase in divorce or marital issues since the COVID-19 pandemic led to stay-at-home orders? So, you know, folks are being asked to stay home. There's kids involved in the process. You know, it may be something that a couple may not be used to. So have you seen any statistics on an increase?
There have been an increase. There's currently a partnership between Maricopa County Coalition Against Domestic Violence and the City of Phoenix Police Department. Their chief of police, Jerry Williams, has been working with the coalition to provide statistics and information. They have partnered together, both of those agencies, to prepare some video, some television, and radio PSAs, public service announcements regarding the issue. They want people to know that they are still there. This is a resource that still exists, even though we are battling a global pandemic right now that is affecting our community here in Phoenix. They want the public to know resources are still available for them. There is a hotline for them to still call into. In fact, there's a few different hotlines, but there are resources available.
Great, great. And we'll provide those resources at the end of the video and on each social media posts. So we'll do that. One thing that I wanted to talk about is there's just a lot of questions in terms of like the divorce, and then you then look at another family law issue like child custody and visitation. You know, there's different requirements that the court has for a parent to abide by, you know, drop-off locations, parenting time, you know, are they being responsible? What are your thoughts on that? Do you think that some of those challenges have increased during this time, or do you think that people are kind of finding the resources that are out there?
Well, I think people are finding resources. There still is some room for improvement, no doubt. But I think what's also happening, to be quite frank with you, is many people are using the pandemic as an excuse to not comply with court orders. And the court is very much aware of that. The presiding judge, Bruce Cohen, has made it clear that right now everybody's to abide by their orders. If someone believes that there is a health, welfare, safety issue, they can file an appropriate motion with the court, and the court will hear it just as they would prior to COVID-19. But if a parent's argument is going to be, well, a child is being taken to the grocery store and therefore the child is around other people and may be exposed to COVID-19, I don't believe the court is going to take well to that. And the court has made it clear, unless there is something compelling like a parent who is testing positive for COVID-19, and then the other parent is saying, hey, let me get the kid because I want to make sure that the child is safe during this period of recovery for the other parent, entirely different situation. If you have a child who needs to travel on an airplane because the child needs to travel because that's part of the court order, and because given the current situation, you know, the orders by our governors that we all stay in home and stay in place and stay safe. So with that, a child should not be on an airplane, and that may very well compromise the child's health, welfare, and safety. And if it is that kind of a situation, the court is saying, file a motion. just like normal, file a motion, get in front of a judge, and then that issue can be addressed. And whenever you're ready, I mean, I'm happy to talk about what are the time frames right now, what are we looking at. If a parent were to file a motion today, it still is going to depend on the judge. It's going to depend on the type of hearing that's being requested and the circumstances. And the reason why it depends on the judge is some judges, they're scheduling hearings within a couple days when a motion to modify parenting time is filed. But if another parent files that same motion in front of another judge, that judge may be setting it out a few weeks or longer. So the judges still maintain discretion according to the presiding judge. It's still up to the judge as to what their availability is, what the calendar looks like. But the sooner that a motion's filed, the sooner the court can address it. One thing I can tell people right now, child support modifications are very much important for people, given the fact that many people have been laid off from work or their hours significantly reduced and their incomes affected. But those are right now kind of being pushed, I hate to say it, and these are my words and no one else's, on the back burner, because the court is really trying to tackle the immediate need of parents who are trying to see their children. But if there's a child support issue, still file a motion. You might be a little while before it's heard, but file a motion. And I believe there's lots of motions are going to be filed because parents just can't pay right now. What I do recommend and what the court recommends in its guidelines is just talk to each other, start there. If the two parents should talk as parents, see what they can work through until we can at least get through this.
Gotcha. And that's an interesting point that you bring up, that they might be using, I didn't think about it, parents could be using this as a way to, kind of the COVID-19 making it work in their favor. So I see that. One thing that I've learned with the other Arizona Attorneys Respond programs is that the courts are simply accommodating their services according to COVID-19, but everything's moving forward per usual. So that's one thing for folks to note, that, if you have a hearing set, you should attend. If you're hearing from the courts, you should probably listen because they're still fully functioning. They're just adjusting their operations to address the COVID-19 pandemic. So definitely some great information, Rachel. I appreciate that.
No problem. And if I can just kind of jump in real quick and just say this, most courts are allowing people to call in and do video conferencing, and that is still along the lines of Governor Ducey's order to mitigate the transmission of COVID-19. So hearings are not taking place in public. If you show up at the courthouse, you're not going to be allowed into the courtroom. I'm telling you that right now because it happens. People think, well, I really don't have a reliable phone, or I don't have a video capability through a computer, so I'll just show up. What I would say is call the court, talk to the judge's assistant, and let them know that you need some type of assistance or consideration as it relates to your method of communication.
Absolutely. Absolutely. Being that we are working remotely, if we're working, we're asked to communicate remotely. Question for you. Is it, you're obviously a very highly skilled attorney with years of experience, but money can be tight during these times. If somebody wants to move forward with a divorce or wants to modify, like you mentioned, child support, can they do that on their own without an attorney?
They absolutely can. I would encourage them to go to the Maricopa County website, Self-Service Center. If it is related to a modification issue or just filing of a legal separation or divorce. If it is regarding an order of protection, the courts created what is called Arizona POINT, Arizona Point. It's the Arizona Protection Order Initiation program. It's a link, and it's a portal that allows people to key in information about their order of protection. They can modify that information if necessary, and ultimately file it with the court and request a hearing with the court regarding an order of protection. So just as you said earlier, business as usual. Things just look a little bit different now, but the court takes all of these matters very seriously and wants things to continue to flow and move forward. We received an administrative order that it may not be for a few months before we have in-person hearings and in-person trials.
Gotcha. Well, great information, as I mentioned, and you know what? It's kind of our new reality. Hopefully, it's temporary, but you know, we're learning to live with it. So,
Sure.
so thank you for that. Um, so now we'll move into some of the more specific questions. Actually, before we do that, one last question, Rachel. Just to clarify, because this is temporary, living arrangements and you know couples and married folk being in the same home a lot more often, feeling those pressures of society and the economy, um, before they decide to divorce or dissolve the marriage, let's talk about separation, because that's also a way to kind of help mediate the full divorce, right?
Well, it can, right. It's a way to kind of put the divorce on pause, if you will. So it's a way to end the community. So you say, I don't want to continue to accumulate assets with you. I want everything to stop as of this point. That's what a legal separation will do. Sometimes people do legal separations because of religious reasons or cultural reasons. They just don't want to do a divorce. It does not have the impact of a divorce from the standpoint of you're still married to that person. So you may not be, the community may not still be accruing, but you can request orders such as parenting time orders, and say, I just want to make sure that I'm still having contact with my child. Let's, how we can work this out. Let's create a parenting plan. So yes, if somebody wanted to file for legal separation, they could. One thing I failed to mention before is if somebody files and they still need to pay, they can actually, once they file, someone from the clerk's office will call them for their debit card or credit card number. If they need to pay by check, they can actually mail a check in or drop a check off. The last thing is if somebody, again, doesn't have the technology available to submit their filing online, but they're able to print their documents and sign them and complete them, they are drop boxes that are available at the court for that purpose. So we're really creative. Just as long as everybody abides by that 6 foot social distancing, it works well. So if somebody else is at the box doing a drop, just wait six feet away and give them that space that they need to complete their transaction and then move forward. So the rules all still apply, even at the courthouse. But like I said, the court is really being flexible and trying to be accommodating given the current situation.
That's great. That's excuse me. That's great information. So now let's dive into the questions from folks that have asked them on social media. So we're going to start off with custody and visitation rights, obviously, because I think that those issues with children can sometimes lead to kind of the bigger divorce. So let's start with that. So the first cluster of questions, there's going to be a few, I think can be answered with one explanation from you. If not, you'll tell me that I'm wrong. Obviously, I'm not an. So we'll make it work. So question, Rachel, do I still have to exchange my child for his mother's visits if she puts him at risk? And you touched this a little bit ago. While he's still there, she takes him out in public and around crowds of other people. What can I do? Follow up to that is, our parenting plan requires that we do visits in public places. What are we supposed to do? So it's kind of like the first one is just going ahead and making those public appearances by being out in public. And then the other one's like, okay, well, we're being cautious, but what do we do? Because it's.
So as far as taking the child out into public, yes, you still must turn the child over even if the other parent is taking the child into public. Really where you're going to run into a situation that you want to bring the court in is, again, if the other parent has COVID-19 or has been diagnosed positive, I should say, with COVID-19, or if the parent is taking the child around somebody who has tested positive, then that is a health, safety, welfare issue that should be brought to the court's attention. However, if the parent is taking the child to, like I said before, the grocery store or running some essential errands, going to the store to pick up some items that are needed, going to the gas station, I don't know if you're going to get much traction from the court. I would say not. You're not going to get much traction from the court saying, oh, well, she had the child out, you know, in a store where there were hundreds of people. As long as she maintains social distancing, the other parent maintains social distancing, I think things are fine. I would also encourage parents to take the necessary precautions with their children, have them wear a mask, which is suggested by the Centers for Disease Control and all of the medical professionals that the president is consulting with. Just take whatever steps are necessary just to make sure the child is safe. But short of that, I don't think that there is. And if the parent isn't making the child wear a mask, I still don't think that is going to necessarily rise to the level of something that the court is going to see as problematic. As far as having parenting time exchanges out in public, still needs to comply. Every court order is still a valid order, even with COVID-19. If for some reason there is something in a court order that compromises what are the guidelines and the orders that have been issued by the governor, then that is something that needs to be addressed with the court. But most orders don't. It just says do an exchange at the library, do an exchange at the park, do an exchange at some other public place. So that means the parents can still drive to that public place, still do the exchange. If there's other people present, stay far enough away from them. Again, maintaining social distancing, and there should not be an issue at all. But yes, everybody needs to comply.
Great, great. Next question is, if we have supervised visitation, so this is kind of getting into like the logistics of it, but the supervisor isn't available, what happens?
From my opinion, I would recommend that the parents, and the court is also recommending this in its guidelines, which I will also pass along to you, the link, Alberto, so that you can pass that along to the viewers so that they will know where I'm getting my information from and kind of what are the expectations of the court. But the court says if you have a person who is a designated supervisor and they're not available, then the parent should work it out and try to find somebody else. I mean, worst case scenario, you file something and you end up in court saying, Judge, we weren't able to find anybody, we don't know what to do. But
Gotcha.
really, if the parents work together and try to find somebody else, they should be able to resolve it. Someone they mutually agree upon, which I know can be difficult. And they can also try to see if any of the professional agencies are still available, given the current pandemic, to provide needs. Their
Sure.
need for a supervisor.
Perfect. And Rachel, you touched on this one earlier, so maybe we've already answered it, but what happens if I live in another state and if I have children right now, can I still have time with my kids? And again, that's being court ordered. So what are your thoughts?
So even though the court may not be agreeable for the child to fly at this time, I highly encourage parents to use our technology that we use to have court hearings and to do our job. That's telephone, video, exactly what we're doing right now. Video, there's different programs that are available and apps that are available to do it. Sometimes you can just use good old-fashioned FaceTime. If you don't have anything fancy to do video conferencing, use your phone and in all of the many apps that exist out there, Marco Polo, I think Duo, WhatsApp, there's a number of them. They can go on their phone provider to figure out which ones. But my point is, still give that parent time if possible. You do not want to be in a position when this is over as a parent of saying, I didn't give them time because of COVID-19. It is not going to fly with the court, and they can take a look at the guidelines to know that.
And that's interesting because my next question was, what happens if I refuse to send my kids to visit with the other parent? It's not allowed. It's not okay.
No, it's not.
Okay.
It's not.
Okay, perfect. So we have a grandparents' rights question before we move on to kind of the questions regarding, oh shoot, COVID-19 affected me financially, so what am I going to do with payments or child support payments? So real quick, we'll get a grandparents' rights question in. It says, I'm a grandparent with a visitation order, but I'm afraid to visit because I'm at risk for COVID-19. So probably in that vulnerable demographic. I'm worried that not being able to visit will reduce my visitation time when things are back to normal. What can I do, or is that even the case?
For starters, that's another situation where I would recommend, if there is a grandparent with some grandparents' rights, that whoever is the custodial parent or person, make that child available to that grandparent using whatever technology is available, FaceTime, telephone, whatever. If for some reason that is just not possible, I do not believe in my heart that the court is going to hold that against the grandparent. There's nothing the grandparent can do. It compromises their health and safety, and
Absolutely.
they're just kind of stuck. But what I would encourage that grandparent to do is make sure they mark a calendar, track all of the missed times so they're aware of it in case it becomes an issue of discussion, a topic of discussion down the road. And then they can look back and say, okay, these are all of the days I missed, and I need my makeup visits. Because I'll be really honest, as just like I'm saying for grandparents with makeup visits, the same applies for parents. So if there's any makeup time that's due for parents, I say a parent should be giving that to the opposite parent at this time. If there's anything owed for grandparents, give it to them, because you want to show that you are the reasonable person and that you are understanding given the current health crisis. You don't want to be the person who uses COVID-19 and waves this banner and says, I can't do anything, I can't comply with anything because of this pandemic. It's just not, in my view, going to be a good look when we all return back fully to normal and the court has all of its motions in front of him or her, and the court needs to make some decisions. You just really want to show that you're caring and you're understanding and you love the child and you realize other people love the child as well, or children.
There's some homework for parents, right? And grandparents. Some homework is, if you're missing a visitation with the child, mark it down. And if technology is available, make it work that way. That also applies to folks that live in a different location. So right now, like Rachel and I are doing, we're taking advantage of the technology that's available. I mean, a phone call even can be as heartwarming as a video call, just because you want to hear your grandchild's voice, your child's voice. You want to hear them tell you that they love you. So, take advantage of the technology that we have. So thanks, Rachel. So here's a little bit, here's a question, excuse me, regarding some of the kind of more logistical issues with losing a job. So I was laid off from my job and I lost my insurance benefits, and I'm required to carry insurance for my child. What do I do? Next question. I was laid off or furloughed from my last job. Is there anything that I can do to modify my required payment? So can I modify payment, and what do I do about not being able to provide that insurance to my child?
I'll start with the insurance one first. As far as insurance, if you don't have insurance available, the one thing you don't want to do is avoid that, especially given the current climate. If God forbid something happens to the child gets sick, you don't want it to be a surprise to the custodial parent that there's no insurance, or the other parent, there's no insurance. So what I recommend is that there's a communication, that there's a discussion between the parents about that sooner than later. I am not naive, and I realize that this, just because we're going through COVID-19 doesn't give everybody the ability to communicate easily with the other party. So I would recommend an email, preferably a phone call, but if that's not going to be possible, an email, and lay out that insurance benefits are no longer available. Then the next step for the parents is to figure out where they can get insurance, whether one of the parents has insurance available that they can obtain from their place of employment. If that's not a possibility, explore other options for insurance, whether it's private insurance or public insurance. But a discussion needs to be held, and it needs to be, from my perspective, a very high priority issue to make sure the child has insurance.
Great.
Okay. As far as if a parent loses their job and their income has decreased, that is another conversation that needs to take place sooner than later. So if the parent has lost their job, their hours are down, and they can't make their monthly child support payments, I recommend that if they can pay something, to continue to pay something. Again, make a note, send an email, put things in writing. I'm a firm believer of things in writing that says, hey, I lost my job, or my hours are decreased. I used to make $5,000 a month. Now I'm making $500 a month, and I just don't have it, but I'm going to enclose $50, or I'm going to send over $50 or Zelle you $50, however your normal procedure is to get money over to them, or send it to the clearance center and say, hey, clearance, I got it. This is all I have. And then when you go back to court, which I'm sure you go back to court because the other parent or you, their other parent's going to file an enforcement action saying you're not compliant, or you can file something that says I need a decrease given my current situation because I don't know when my hours are going to go back up. I don't know what the future is going to hold for me economically. And then at that point, the court can hear the issue and make a decision. But communication is key. And if you can do something, do something. But communication, verbal, but I also recommend any verbal conversations be followed up in writing.
Great. And just to end kind of the child support and custody side of things, here are two questions regarding garnishment for, one, the stimulus check, two, unemployment benefits. So I lost my job, I'm getting unemployment. Can those be garnished? Excuse me. And then the other one is, can my stimulus check be garnished, or at least a portion of it?
Right. As far as the stimulus check, if the parent is already behind in child support, it likely will be intercepted. And then what I mean by that is, like, for instance, if somebody files their taxes and they're entitled to a refund and they don't see that refund because they owe quite a large amount or what very past due in their child support, and it's just taken, and then they later find out it's been applied to that debt, then that's what that is. That's intercepted. So in this instance, stimulus checks can be intercepted for parents who are behind on their child support payments. So what I recommend parents do is, if they're interested in getting their stimulus check and they're concerned they might be one of those people, that they follow up with their state child support enforcement office and find out if there's a likelihood that their check will be intercepted. As far as, let me see, was intercepted, and then the other one was
unemployment benefits?
Unemployment. As far as unemployment, that one I think is a little bit trickier, but I would say because it is income that they would still have to pay child support on it. But that is going to vary, right? Because we know what their child support payment amount was before they were collecting unemployment, but it would obviously decrease based on their unemployment amount.
Gotcha. And this is kind of leading into the divorce field, but still involves kids. If my divorce decreases and my ex and I alternate each year when we claim our kids on our taxes, who gets a stimulus payment for our 3 kids? Whoa.
I think that's a great question, because that's something we just don't know, right? Because this is all brand new to not only us as attorneys, but it's also new to the parents and then, of course, the court. So I can't answer that because we haven't experienced it. But what I can say is that I think it's something that's going to need to get in front of the judge. If one parent keeps the check or takes the amount of the check out of a mutual account that they have, I believe the other parent would have some recourse by going in front of the judge and saying, hey, they took my share of the stimulus check, I want it back. And then they can request that those funds back. But as far as who gets to claim on the taxes, the court hasn't even touched that topic yet. But if a parent wants immediate direction on that, they would need to file something with the court and saying, what do? I just don't know. And I don't know as an attorney, unfortunately, because we just haven't seen enough of that yet. And from what we've heard from the judges, they're like, we don't know what we're going to do. It's going to be on a case-by-case basis. It's very fact-specific.
Sure. Okay, perfect. Again, we're relying on the courts to help us interpret all of their actions. So perfect. Okay. Another question is, and this is stimulus check associated as well. My wife and I filed divorce papers, but we haven't had our first court date. Do I have to pay child support right now before anything is determined? Although we had an agreement on our own, but now I've lost my job. So our court date has been pushed back. Do I have to pay something that wasn't court ordered? And I'm sorry, that one's not stimulus related, but it is lost his job or her job, and they don't have, the capacity.
Okay, so what happens when people file documents with the court, especially some type of an agreement, a stipulation, or a consent agreement is the formal term in family court? When they file that with the court, they're saying, I'm willing to do X, Y, and Z. And in this case, pay more than what they're now realizing they can pay. So to answer your question, they do not necessarily have to pay that amount yet without a court order. So you may say, well, wait a minute, we just said we are agreeing to something. So why would there be a court order? Because any agreements need to be signed by the court and approved by the court. So then the court signs off and approves any agreements. If the court hasn't approved that agreement yet, no, there's not any orders that they need to comply with. However, if your situation has changed from the time that you filed to the current time before the court has signed off on it, I think you need to file something with the court right away. You need to let the court know, yes, I agreed to this, but Your Honor, I've had a huge change in situation, so I'm asking you not to sign off on that order, because if the judge signs off on it in a couple of weeks, then they're going to be on the hook for that dollar amount in a couple of weeks. But if they don't want that judge to sign off, they need to get something filed sooner rather than later to let the judge know their circumstances has changed, because otherwise the judge is going to believe that everything must be the same because they haven't heard anything and the parties have agreed.
Gotcha. So some homework for you is get to the court and not physically, but, file something with the court to make sure that you get ahead of the judge issuing that order. So thank you for that, Rachel.
You know what I didn't mention to you also, Alberto, the courts are open. All of the courthouses, I'm thinking right now, except for Seth, the Southeast facility in Mesa on Javelina is closed, but they are open for very limited things. So you can't go there for a hearing. If you need to file something, you will be confronted at the hard work, but a security person will come out and say, how can we help you? You would have to explain that you're filing something. Their job is to make sure that you're 6 feet away from anybody else. You will have to go in quickly, file, and leave. So there are some facilities that are taking people still in person, but my understanding is Southeast facility is closed in its entirety. I don't know when it's scheduled to reopen, but all of the other places you can go, but many of these same things you can, you can contact the clerk's office if you have any questions regarding filing.
Perfect. And these two, while they're a little lengthy, I believe their answers might be a little easier than not. But again, you're the attorney, so you make it work. My wife and I filed for divorce, but it hasn't been finalized. We've been using separate bank accounts for the last few months because of the new step in their future. But my ex kept our old account and received our stimulus payments by direct deposit. How do I get my money? Just ask for it?
Yeah, you ask for it first. That's right. Just do the human thing, ask. And then if you get a no, you can follow it up with writing with another ask, because you want to document that you've asked and that in writing. And then if you still don't get it, you can file something with the court and say, Judge, the stimulus check was clearly deposited. Here's a screenshot. And I haven't received any of those funds and I'm asking for my fair share. I think it's an easy one, I think, for the court. It's equity. It's just being fair.
Perfect. And then the last one, before we talk about some resources, is there any idea when a default divorce hearings will be heard? So I think you said they're still being heard. On May 5th, I will be able to file for the third try because of clerical errors. Sorry about that. For a default decree without a hearing, and I am familiar on how to do this without a hearing, but was wondering if it made sense to wait until the court hearing is hearing cases again, or attempt again for it to be done without a hearing and mailed. So
do it now. Go ahead. The court is looking at defaults, how they're putting them in the hierarchy of priority as far as scheduling hearings. I can't answer that. I just simply don't know. But if you have a default, still push forward with it. And if there's any kind of issue or the court is not going to consider them, then you will find out that. But I would definitely go ahead and file, because we don't know when the quote end of this is going to happen. And so if you've had a party who has not responded, then you want to go ahead and make that known to the court now.
Perfect.
If the court is working specifically, that is one of the hot topics for them, besides everything else we've talked about, is how are they going to handle defaults. But right now, things are going to be normal, still file.
Gotcha. So just some reminders for folks. The courts are working. It's just they're taking a different approach, taking advantage of technology, taking advantage of a phone call. So make sure that you guys are on top of everything that has been ordered in your specific case. Am I correct?
Yes, you've got it. That's 100% right.
Perfect. And then in terms of domestic violence, I know we started off with that, but it's important for us to really let folks know that, yes, we are seeing an uptick. You're seeing an uptick. The media is reporting an uptick in domestic violence, and it's not something that they need to wait for this to end to address. There are resources out there. There are people you can talk to. Like you mentioned earlier, there are some hotlines that we'll include when we post these videos. But you know, I believe even some local like restaurants. I think I heard that some pizza chains are getting creative. If you order a specific kind of pizza, that's kind of their trigger to say, okay, this person needs help. So, you know, there's definitely help out there. People know that this is going on, so you're not alone. They are there to help you and want to help you. So I don't know if you have anything to add to that, or if you feel that we have any gaps that we need to fill in the overall family law topic.
Mm-hmm. I don't think so. I think we've covered everything as it relates to family law. If you get a question, please don't hesitate to reach out to me. And for the viewers out there, I'm Rachel Johnson again with Rachel Frazier Johnson Law, but Alberto's wonderful. He'll reach out to me and he'll let me know if there's a specific question, but I'm happy to answer it. As far as domestic violence, just like I said earlier, I hope I mentioned the statistic, 15% increase since mid-March. And so it's happening close quarters, whatever the issues are, the issues still exist. The difference is that the people are still home and having to be home the majority of the time, which can in and of itself agitate, aggravate, and enhance difficulties. So remember that isolation is one of the ways that domestic violence perpetrators are able to take advantage of their victims and abuse their victims. And so it's super important that in this isolation that we are currently experiencing with the stay-at-home orders, that we be vigilant, with that, and we're on top of it, we're aware, and we're sensitive to those people out there who may need help. Governor Ducey in his orders explicitly stated if somebody needs to leave their home and seek alternative housing because they are the victim of domestic violence, they can do that. The governor took the time to write that in his order for a reason, because he wants people to know you are not a prisoner in your home. You're not a prisoner to domestic violence or any other type of abusive situation that may be occurring. So there are resources, as you've mentioned. I will be sure to send over some links to the different hotlines. And just like you said, Alberto, there are pizza places, and there's even people who are saying to their community and their social media community, let's create a safe word. And if you send me that safe word, I don't care if it's via text, phone call, or on social media, I know I need to call the police for you. And I'm prepared to do that. So we're seeing people come together as a community to really take care of each other, whether it's somebody who's sick with COVID-19, somebody who is suffering the effects of domestic violence. We still are a community, we still need each other.
Absolutely. And one thing to mention is emergency services are still available, police, fire, paramedics. So, you know, if you can't make the phone call, somebody will make that phone call for you. So with that being said, Rachel, I want to thank a few people before I let you go. I want to thank the Arizona Foundation for Legal Services and Education. They help to funnel some of these questions that we're getting from the public. Obviously, the foundation is one of the main go-tos in the community for getting free legal help, and this is, you know, a program that we hope is helping their audience. So thank you, Foundation, for helping us get these questions from the public. I want to thank the State Bar, obviously, because they are doing a great job in addressing the legal gap in the community, especially during this time. But the biggest thank you is to you, Rachel. I appreciate you taking the time to address these questions. Again, the public has found these videos to be so important and so valuable. And with the information that you provided, specifically with family law, because that was actually one of the ones that was requested there. You need to get these questions answered. So I want to thank you for volunteering and taking the time to address the public's question. There are definitely a ton of other lawyers who are just as committed to helping the public like you are. So again, a heartfelt thank you, Rachel, and we appreciate the time that you gave us today.
Thank you, and I appreciate you, and I appreciate your audience just taking the time to listen to what I had to share today, and of course the questions that you offered. I think it'll make a big difference in just educating all of us.
Absolutely. So thank you so much again. And next week, we'll see you with a new topic. Keep an eye out on social media. And also share your ideas for topics that you might be experiencing during COVID-19. We've focused on family law. We've focused on bankruptcy, landlord and tenant. Are you having maybe some business issues? You're a small business. Do you have some questions that you want answered? Let us know and we'll help you. Okay. So thank you again and hope you all have a wonderful week.
Thank you.